than it did on the 1st of January 2010.
Muchas gracias, señor Perito, por su dictamen inicial. Estamos seguros que el mismo quedará en el expediente para estudio de la Corte, ¿no es cierto? Muchas gracias. Entonces iniciamos las preguntas a cargo de la representación de las presuntas víctimas. Le doy la palabra.
Good afternoon, Mr. Wintermute. First of all, where did you obtain your PhD degree?
University of Oxford in England.
Thank you. What is the title of your degree thesis?
It's quite long. I'll give you the short version, published as a book by Oxford University Press in 1995. Sexual Orientation and Human Rights, the United States Constitution, the European Convention, and the Canadian Charter.
Thank you. And do you have any teaching experience?
Yes, I teach at King's College London, and the subjects I generally teach are European Union law, human rights law, in which we focus on the European Convention on Human Rights, and anti-discrimination law.
Thank you very much. After your detailed statement, I would like to ask you, what has the European Court decided in its judgments concerning, in particular, lesbian and gay parents and prospective parents?
Yes, the court has decided, has issued 2 judgments in this area. And essentially what the court has said is that its general non-discrimination principle, which guarantees equal opportunities for lesbian and gay individuals, also applies in the area of parental rights when you're talking about a particular parental right that is available to a heterosexual individual, such as the right to apply for custody of children after divorce, or the right to apply for adoption as an individual in countries that allow individuals to apply to adopt children. So that's the general effect of the 2 decisions. The first judgment is in the case of Mota versus Portugal in 1999, very similar to the case of Atala versus Chile. Essentially what happened was that the first instance court granted custody of a girl to her gay father. The heterosexual mother appealed to an appellate court, which changed the decision and gave custody to the heterosexual mother. The gay father took his case to the European Court of Human Rights and argued that the reasoning of the Portuguese Court of Appeal was discriminatory, that the language used indicated that his sexual orientation was being treated as a negative factor and held against him in the reasoning of the Court of Appeal. The first thing I'd like to point out about the judgment actually is the European Court always starts by summarizing the arguments of the parties, including the government, and this is how they summarize the argument of the government of Portugal. The government of Portugal said, in this field in which the child's interests were paramount, the national authorities were better placed than the international court. The European Court should not substitute its own interpretation of things for that of the national courts, unless the measures were manifestly unreasonable or arbitrary. The Court of Appeal, in reaching its decision, had regard exclusively to the overriding interests of the child and not to the applicant's sexual orientation. The applicant had not been discriminated against in any way. That was the argument of the government of Portugal in the case. It was rejected by the court. The European Court found that in reversing the decision of the first instance court, the Court of Appeal had introduced a new factor, that the applicant was a homosexual and was living with another man, and they said that this was a difference of treatment between the applicant, the gay father, the daughter, and the heterosexual mother of the daughter, and that this difference of treatment was based on the applicant's sexual orientation. Now, the court had to consider whether or not this difference of treatment was justified, and this included examining whether there was a relationship of proportionality. And the way the court framed the question was, they asked these statements about the Court of Appeal relating to Mr. Mota's sexual orientation, were they merely obiter dictum, which had no effect on the outcome, or were they decisive? That is how the European Court framed the question. And these are the key statements made by the Portuguese Court of Appeal. That court said the child should live in a traditional Portuguese family, and that homosexuality is an abnormality, and children should not grow up in the shadow of normal situations. This is similar to paragraph 20 of the Supreme Court of Chile's judgment. Now, according to the European Court, this language, this reasoning, far from being merely clumsy or mere obiter dicta, this language suggested that the applicant's homosexuality was a factor which was decisive in the final decision. So those are the two of the statements that the court referred to. Homosexuality is abnormal, and that his family was not a traditional one. Another statement they referred to was that the Portuguese Court of Appeal warned Mr. Mota not to adopt conduct which might make the child realize that her father was living with another man in conditions resembling those of man and wife. This is similar to paragraph 16 of the Supreme Court of Chile's decision. The conclusion in Mota, this is a 7-judge chamber of the European Court, was unanimous in finding a violation of Article 14 combined with Article 8 on respect for family life. I'll restate the court's conclusion that the Court of Appeal made a distinction based on considerations regarding the applicant's sexual orientation as distinction which is not acceptable under the Convention.
Mr. Wintermuth, there's another more recent case. Could you explain it to the court, please?
Yes, that's right. The more recent case was decided in 2008. It's called EB versus France. It does not concern a custody decision. It's about applying to be eligible to adopt a child. The issues are very similar to a custody decision. What has to be understood is that in France, and as in almost every country, there's a preliminary assessment of whether or not an individual is suitable, has the necessary qualities to be a potential adoptive parent. This is done before any child is identified and placed with the potential adoptive parent. EB was a lesbian woman in France who applied to be declared eligible to adopt a child. Her application was rejected. 2 reasons were cited, and one reason in particular was that if she adopted as an unmarried individual, which the French Civil Code permits, there would be no paternal referent in her home. In other words, there would be no man living in the home, no father figure. Now, the French government argued that this was not a difference of treatment based on sexual orientation, that this was something different. Now, the overall decision in the case, the issue in Mota was, may an individual's sexual orientation be treated as a negative factor in deciding which parent should be granted custody of a child? That was the question, and the court essentially said no, it's discrimination to treat it as a negative factor. The issue in EB versus France is when an individual is applying to be declared eligible as a potential adoptive parent, may their sexual orientation be treated as a negative factor, and may their application be rejected on that basis. The principle of the EB versus France judgment was stated most succinctly by the President of the European Court, Judge Costa, in his dissenting opinion. Now, this is a bit strange that it's in the dissenting opinion, but what happened was the vote essentially was 14-3 on the principle. He agreed on the principle. The application of the principle, on the application of the principle of the facts of the case, the vote was 10-7. So he did not vote for a violation, but he agreed on the principle. And this is what he said. The message sent by our court is clear. A person seeking to adopt cannot be prevented from doing so merely on the ground of his or her homosexuality. Our court considers that a person can no more be refused authorization to adopt on grounds of their homosexuality than have their parental responsibility withdrawn on those grounds, citing Mota. I agree. So that was the principle of the decision, but I must stress that it only applies in countries that allow individuals to apply to adopt as an individual. The case was not about second parent adoption or joint adoption, where a same-sex couple applies to both simultaneously adopt the same child. Now, if I could, shall I explain the reasoning
Okay.
of the court? The starting point for the majority of 10 judges was that the illegitimacy of one of the grounds has the effect of contaminating the entire decision. So essentially there were two reasons for the decision. The ground absence of or lack of a paternal referent was seen as discriminatory, discrimination based on sexual orientation. The other ground, the role of EB's female partner, was considered non-discriminatory. But for the majority, one discriminatory ground was enough. The court found that the use of paternal referent was essentially a difference in treatment based on sexual orientation. And there's some language similar to paternal referent in paragraph 17 of the Supreme Court of Chile's judgment. For the majority in EB's versus France, they reached the inescapable conclusion that the applicant's sexual orientation was consistently at the center of deliberations and omnipresent at every stage of the administrative and judicial proceedings. They found, as in Mota, that the applicant's sexual orientation was a decisive factor leading to the decision to refuse her authorization to adopt, and that the difference of treatment could not be justified. France had not provided particularly convincing and weighting reasons, therefore discrimination based on sexual orientation, violating Article 14 combined with Article 8.
Thank you, Mr. Wintermuth. Let me take you to another ground. How does the case law of the United Nations Human Rights Committee compare with the case law of the European Court?
Sorry, could I just add one further case from the European Court of Human Rights,
Okay,
which is important because the Mota case actually applied a prior judgment of the court, Hoffman versus Austria, from 1993. And it's the question of social discrimination against children of lesbian and gay parents is not discussed in the Mota and EB cases. It did not come up in the national court reasoning and therefore was not discussed by the European Court. However, it is mentioned in Hoffman versus Austria, which is procedurally similar to Atala versus Chile in the sense that there were 3 levels. The first 2 levels awarded custody to the mother. The third level, the Supreme Court of Austria awarded custody to the father. Now, what's of interest in this case is paragraph 33, where the court says, in that case it involved a mother who was a Jehovah's Witness. The court accepts that there has been a difference in treatment, and the difference was on the ground of religion. This conclusion is supported by the tone and phrasing of the Supreme Court's considerations regarding the practical consequences of the applicant's religion. Now, it's interesting to look at paragraph 15 of the court's judgment, in which it quotes from the Supreme Court of Austria. And in the last paragraph, there is a statement that if the children are educated according to the religious teaching of the Jehovah's Witnesses, they will become social outcasts. The court does not refer to this specifically, but it seems quite plausible that that's part of the tone and phrasing that they had in mind, and particular evidence that religion was a factor in the decision. I would just also note that similar language is found in paragraphs 15 and 18 of the Supreme Court of Chile's judgment.
Thank you. Let's move on because we have a little more minutes. How does the case law of the United Nations Human Rights Committee compares with the case law of the European Court, please?
In most respects, it's similar. There are, less abundant. There are 3 decisions instead of 16 judgments. There is one decision from 1994, Tunin versus Australia, which is very similar to Dudgeon versus United Kingdom, same issue, laws in the Australian state of Tasmania criminalizing all sexual activity between men. They were found to violate the right to privacy in Article 17 of the International Covenant on Civil and Political Rights. And here I would note the committee's statement that it is undisputed that adult consensual sexual activity in private is covered by the concept of privacy in Article 17, the equivalent of private life in Article 11.2 of the American Convention. That was the first decision of the committee. Since then, the committee has issued 2 decisions in similar cases, one called Edward Young versus Australia in 2003. The other was X versus Colombia in 2007. The issue in these 2 cases was the same. It were, in both cases, it was a question of a survivor's pension, whether or not a pension benefit could be transferred to the surviving partner after the death of the person entitled to the pension. And in both cases, if the surviving partner was of the opposite sex, they were entitled to the pension benefit, even though they were not married to the deceased person. So unmarried different sex couples qualified in both cases. Same-sex couples were excluded. In both cases, the committee reached the same conclusion, which was that the prohibition against discrimination under Article 26 comprises also discrimination based on sexual orientation. Both cases, they found a clear difference in treatment based on sexual orientation. No sufficient justification had not been provided by Australia or Colombia, therefore violation of Article 26 of the International Covenant. As to how the court would decide a child custody, as the United Nations Human Rights Committee would decide a case in which a lesbian or gay individual sought access to a parental right available to a heterosexual individual. In the case of a custody decision where sexual orientation is being treated as a negative factor, the 3 decisions suggest that the UN Human Rights Committee would be likely to follow the reasoning in Mota versus Portugal.
Con su venia, señor presidente, podríamos utilizar 2 minutos. Me queda solo una pregunta.
Por supuesto, y le voy a pedir al señor perito también que tengamos un poco más de concisión en las respuestas porque todavía faltan varias preguntas. Adelante.
Gracias. The final question, Mr. Wintermute. Is there a slippery slope from custody for lesbian mother to marriage and joint adoption for same-sex couples?
Not at all. An international human rights tribunal may develop its case law by considering one issue at a time. This is exactly what the European Court has done. It started with a blanket ban on all sexual activity between men. It then turned to other forms of discrimination in the criminal law, then to discrimination against individuals in employment, then there was a question of parental rights, custody after divorce, and then to rights of unmarried couples. Now, I think what it's important to note is the European Court decided in favor of Mr. Mota in 1999, and that decision did not in any way commit the European Court to finding, under the European Convention, a right for same-sex couples to marry and adopt children jointly. Today, nearly 12 years after the Mota judgment, the European Court has yet to find those rights. So if I could conclude, my opinion would be that the European Court is by no means a radical court. It always keeps its eye on European consensus with regard to the human rights issues it's addressing. I would therefore respectfully suggest that the case law of the European Court is not only a source of persuasive judicial reasoning for the Inter-American Court, but also a source of reliable guidance as to what kinds of decisions the majority of governments in the Americas would find acceptable.
Thank you very much. Finally, are you willing to handle a written report for the court?
Yes, I will have a draft with some footnotes, and I will be happy to send it from London as soon as I get back.
Thank you very much, Your Honor. I don't have more questions.
Muchas gracias, señor Escobar, y desde ya nuestro agradecimiento al señor Perito por el informe que nos va a entregar en su momento. Agradeceríamos después coordinar con Secretaría los tiempos para que esto pueda ser de conocimiento de las partes antes de que presenten los alegatos finales. Le doy la palabra a la representación del Estado. Señor agente González Morales, tiene la palabra.
Muchas gracias, señoría. Sí, en relación con el desarrollo del proceso de consolidación de la orientación sexual como categoría sospechosa, ¿es correcto pensar de que ha tenido una evolución más rápida en el sistema del derecho europeo que en el sistema interamericano de derechos humanos?
Yo diría que ha habido una evolución en el sistema europeo solamente porque casos han llegado a la Corte de Estrasburgo. Las Cortes no pueden pronunciarse sobre cuestiones de derechos humanos sin casos. Entonces, si no hay evolución sobre el tema de orientación sexual en la jurisprudencia de la Corte Interamericana, es porque casos no han llegado. Una cuestión más general sería, se puede notar una evaluación jurídica en los países de las Américas acerca de las cuestiones de orientación sexual. Yo diría que sí, hay muchos ejemplos que se podrían citar.
Muchas gracias. Para que se aplique un criterio de escrutinio estricto, tiene que estar previamente consolidada la categoría sospechosa, porque si no es muy difícil de anteponer, digamos, la evolución en materia de categoría sospechosa a que los tribunales hagan ese examen de criterio estricto. Desde ese punto de vista, ¿existe en el derecho europeo, en la jurisprudencia europea, algún caso en que los tribunales hayan aplicado primero los criterios de escrutinio estricto antes que existiera la consolidación del concepto de orientación sexual como categoría sospechosa?
Yo diría que la Corte Europea ha construido su jurisprudencia caso por caso. Ha comenzado con el sexo. En el caso Abdulaziz contra Reino Unido en 1985, había una discriminación clara, directa, fundada sobre el sexo. Era más difícil para una mujer pedir un permiso de residencia para su esposo que para un hombre. Y en esta sentencia la Corte dijo por primera vez que las diferencias de trato fundadas sobre el sexo exigen razones muy ponderantes, no sé cómo decirlo. Entonces, nunca no se ha decidido, debemos construir una gran teoría, toda construida antes de aplicarla. No, la Corte lo ha hecho caso por caso.
Muchas gracias. ¿Diría usted que el nivel de desarrollo del concepto de categoría sospechosa para la orientación sexual están a la par en cuanto, digamos, al consenso generalizado? ¿Están a la par en Europa que en América Latina?
Yo creo que no, yo creo que hay muchos datos en las Américas porque se ve en la legislación nacional en muchos países. La ley sobre la discriminación incluye orientación sexual. Hay varias constituciones, como en Ecuador, etcétera, que incluyen orientación sexual. Hay sentencias de cortes nacionales. Hay muchos datos que demuestran la misma tendencia en las Américas que en Europa. Yo diría, lo que pasa es que cuando una corte internacional o nacional debe interpretar un artículo que prohíbe la discriminación, se debe aceptar que la gran mayoría de diferencias de trato hechas por los gobiernos se pueden justificar. Los gobiernos hacen diferencias de trato millones de veces al año y toda la legislación es una serie de diferencias de trato. Entonces, cada corte tiene que decidir cuáles motivos de diferencia de trato deben estar tomadas más en serio, que cuáles son más difíciles a justificar. Y la construcción de la teoría de la lista de categorías sospechosas depende de la orden de llegada de los casos. Y en Europa comenzó con el sexo. La Corte dijo casi nada sobre la raza hasta 2005. ¿Por qué? Porque no había un caso. Entonces, he leído un poco sobre la jurisprudencia de la Corte Interamericana y tengo la impresión que no hay tanta jurisprudencia sobre la discriminación, categorías sospechosas, etc. Pero no hay ninguna razón por qué la Corte no puede comenzar con la orientación sexual, porque es el primer caso que llegó. Otro caso llegará y la Corte puede extender poco a poco a otros motivos. Pero no veo ninguna diferencia entre Europa y las Américas.
Y siguiendo con el desarrollo del tema de la orientación sexual como categoría sospechosa, ¿la jurisprudencia europea es uniforme, es unánime respecto de este tema o hay fallos en sentido contrario?
Fallos contrarios. No hay fallos contrarios sobre los principios, ¿se dice? Principios generales que describí al principio. No, estos son uniformes. Lo que se puede variar es la aplicación de los principios a casos concretos y las únicas excepciones en este momento son el acceso al matrimonio y derechos que son reservados a parejas casadas. Y en este caso los mismos principios se aplican, pero la Corte llega a la conclusión que sobre todo visto el nivel de consensus en Europa, el desarrollo de la legislación nacional, no hay una violación en estos casos. Pero los principios son uniformes.
Muchas gracias. Una última pregunta. Desde su perspectiva, ya que en el peritaje anterior hablamos in extenso sobre el tema de la discriminación por orientación sexual y los derechos o el interés superior del niño. ¿Usted podría darnos su opinión respecto de esas dos situaciones cuando se produce un conflicto? ¿Cómo lo resuelve el derecho europeo?
Perdón, señor Perito, hay una objeción por parte
Objeción, su señoría.
de la representación de las presuntas víctimas. Tiene la palabra.
Señor presidente, el objeto de la pericia está claramente expresado en la resolución y no se hace ninguna referencia al interés superior del niño.